the general message is that also during these COVID-19 times, the labor law continues to apply almost in full amount. So there are very few exceptions, but I will speak about them a bit later. But in general, so even in these crisis situations, so the paid leave can be taken if the employee actually agrees to take it. So there is no right of the employer to impose an obligation of the employee to take paid leave. The same is with unpaid leave. So the and here it is even more strict. The initiative to take unpaid leave has to come actually from the employee. So then in order to be fully compliant, the employee himself or herself must write an application to the employee stating that the unpaid leave is needed. As to salary decrease and working time decrease, then amendments to employment contract are required, and it is mandatory. As to cancellation or suspension of non-contractual remuneration schemes, then it is possible to cancel them with or suspend them with 1 month's prior notice. Of course, in this case, it is also, as in previous cases, it is also required to prior consult with employee representatives, but in Latvia the peculiarity is that in case there is lack of employee representatives in the company, there is no requirement to consult with employees. So basically, in a standard situation, there are no employee representatives in a private company. So these measures, including the last one, termination of employment due to redundancy, can be implemented without consulting with anybody. The situation is a bit different when it comes to termination of employment due to redundancy with employee who is a trade union member, because it is possible that there are no employee representatives in the company, but some employees still are trade union members somewhere. In such case, they then their employment can be terminated only in case the trade union consents to such employment termination. With a precondition that these employees have been trade union members at least for 6 months, at least for last 6 months. The next slide, please. A few words about idle time. So if employer has not implemented any of the previous measures and still cannot employ the employees because there is simply no work, then this is idle time situation. In other words, it is a situation when the employee is ready to work, but employer for any reason is not able to provide work to the employee. And under Latvian law, in such situation, the employee still must be paid full salary unless the idle time has been caused by the employee himself. So this COVID-19 situation is not an exception from this general rule. However, amendments to this general principle are expected. So they will come. It is expected that they will come into effect quite soon, and that they will be valid until end of this year. And they would allow for the companies who are participants in so-called in-depth cooperation program maintained by the Latvian tax authority. So these companies would be allowed to pay, in case of idle time, would be allowed to pay to the employees 70% of their salary. And also it would be allowed if there is trade union organization in the company, and if there is collective agreement concluded, then it would be possible to so to say impose an obligation to work reduced working hours on all employees. But as I mentioned, there is very poor, I would say almost non-existing trade union coverage in a private sector. So this there will be very few companies which could benefit from this collective agreement exception. The next issue, which sometimes is problematic, is how to choose who will still work and who will be on idle time. So and under Latvian law, there are no criteria. So any objective criteria the employer could think about would be sufficient for this for making the choice. And under Latvian law, there is no specific procedure for announcing idle time, so it is just the fact itself. If the employee is not employed, this is idle time, and the employer has to pay. The next slide, please. So a few words about state support. So when it comes to employers and employees, so one of the most popular support form is so-called idle time benefit. So and under this support scheme, 75% of the employee's monthly salary, however not more than 700 euros, is paid by the state. And also additional 50 euros are paid by the state for each dependent child of the employee. So employers can apply for this idle time benefit if income from commercial activity in March and or April this year has decreased for 30% in comparison with average monthly income in the last year. And partial idle time is not covered by the benefit, and Latvian law does not have such concept as a partial idle time, but it is developed by the Latvian tax authority, who is managing this idle time benefit program. And in practice, it means so that in case the employee, let's say, works only half time, for example, 4 hours per day, or every second week, this is not regarded as so to say real idle time, and in this case, the idle time benefit is not paid at all. And this has and also this has led to the situation that approximately 40% of applications for idle time benefit have been rejected. The main reason still, though, being that the companies applying for this idle time benefit have a unsettled tax debt. So and so far the benefit has been granted to more than 25,000 employees, but still there is a public debate and many opinions that this idle time benefit program has actually not reached its aim, because too many employees are left outside it. Other available support forms are idle time support benefit up to 180 euros. This is a benefit for those who have been refused to qualify for the, so to say, normal idle time benefit. COVID-19 related incapacity from work periods are fully paid by the state, but in such case, of course, the employee must have official diagnosis of COVID-19 disease, and also those who have been put in quarantine with this employees, their incapacity from work will be also fully compensated by the state. There is also a possibility to apply for division of tax payments in parts or deferral for up to 3 years, and this apply also to both to individual income tax and also mandatory social security contributions. And in case of collective redundancy, the employer can request the state employment agency to shorten the 30 days prior notice period. So then this then the procedure, this time frame for the collective redundancy can be remarkably shortened. Then very few words about remote work. Also, like in Estonia, in Latvia, it is possible also if the parties agree to work remotely. So then there are amendments to work safety law, which will be effective from 1st of July, where this remote work will be first mentioned in Latvian legal system. Until now, so there are basically two general rules that unless there is different agreement, the employee must work at the employer's undertaking, and the employee and the employer has to cover all related costs. Then also work safety issue is of important role where the employer is generally liable for work safety, but of course the employee has to cooperate, has to provide all information, including photos, videos of the working place, and so on. And of course it is also important to conclude agreement regarding who will cover what costs. Confidentiality, data protection issues, and of course the manner of recording of working time. Thank you. This is all for Latvia.